administrative documents. The claimant failed to produce the state directive/policy issued by the executive governor of Bayelsa State before the court, that oral evidence of the existence of a government decision or practice or fact of a public nature is legally inadmissible, relying on sections 124 sub 1 and 89E, as well as 90 sub 1C and 54 of the Evidence Act, and the case of Sat Oil Nigeria Limited against Induction Nigeria Limited. That Exhibit BM4, being relied upon by the claimant, is a news report of the government directive referred to, and not an official document containing the said directive or policy. That the directive of the Bayelsa State Governor for all parks to be moved to the transport terminal at Igbogeni did not entitle the park owners to indiscriminately enter the premises to operate, but same was done on the basis of control and management by an authority which has been put in charge of the facility. That it is the former allocation of loading and office spaces to their union that has enabled the NURTW to operate at the said Igbogeni transport terminal till date. And it was also upon the directive and designation of Ekeke Motor Park as an intrastate park that the first defendant got formal admittance and permit to operate at the park from the Yenagoa Local Government Council, as shown in Exhibit NURTW1. That even though the second defendant and the Bayelsa State Transport Company did not enter the park arbitrarily to operate, but with due permission and authority from the appropriate authority, that there is no contractual right inuring to the claimant to gain unregulated access to the Ekeke Motor Park to carry out his transportation business by dint of the directive of the state governor, and the claimant has no enforceable right in the circumstances of this case. Counsel referred to the case of Egbota against PI and PD Company Limited. Citation is supplied. It was further submitted that there is no contractual obligation on the Yenagoa Local Government Council to open this facility, that is the Ekeke Motor Park, to all and sundry transport operators to have unregulated access without obtaining the requisite permit or authority from the local government council. That since the Ekeke Park belongs to the Yenagoa Local Government Council, the council has the right to determine how the facility will be used, and has therefore granted the first and second defendants, including the Bayelsa Transport Company, the exclusive right to use the facility. That in law, the owner of a property reserves exclusive right to use the property as he desires, relying on the case of Okoko against the Honorable Minister of Environment, Housing and Urban Development. That the claimant's relief G is not grantable because then we violate the rights of Yenagoa Local Government Council, since there is no contractual obligation on the council to allocate a space to the claimant pursuant to the directive of the park, pursuant to the directive of the state governor designating the Ekeke Motor Park as the intrastate park, that a court should not lend itself to aid the perpetuation of illegality, relying on the case of SDC Cement Nigeria Limited, again, Aseco Limited. The court was urged to resolve the two issues in favor of the first defendant and dismiss the suit. It is pertinent to note that at the hearing of the suit on the 9th day of December 2025, the learned counsel to the first defendant further submitted by way of adumbration that exhibits MBR1 and MBR2 annexed to the claimant's further affidavit filed on the 20th day of May 2025 should be discountenanced because they were made during the pendency of the suit, hence inadmissible in evidence. Reference was made to the case of Anagbado against Farouk. It is apposite to note that the claimant filed a further affidavit of 22 paragraphs in response to the first defendant's counter affidavit on the 20th day of May 2025. Annexed to the further affidavit are documents marked exhibits MBR1A, MBR1, MBR2, MBR3, and MBR4. The learned counsel to the claimant also filed a reply on points of law, wherein it was submitted that having admitted the fact of the directive of the governor of Bayelsa State in paragraph 5M, sub 1 and 2 of the counter affidavit, the first defendant cannot turn around to deny same, as admitted facts need no further proof. The first defendant cannot appropriate and reprobate at the same time. Counsel referred to Nigerian Shipbuilders Limited against Tamuno, Alero against Saidu, Sylvia against INEC, and Ude against Uwara. Citations are also supplied. That contrary to the submissions of the first defendant, at paragraph 1.06 of the written address, the claimant does not seek a legal right against the government of Bayelsa State over its policies, but against the first and second defendants for their high-handedness at the park, as can be gleaned from exhibits MBR2 and MBR3, that the facts of the suit speak for themselves. Hence, the court can draw inference from the facts, relying on the case of Ogbechi Nigeria Limited against Alhaji Lukman and Chud Vertical Company Limited against Efesinachi Industries. Citations are supplied. That apart from the directive of the Executive Governor of Bayelsa State, the third and fourth defendants have a working relationship with the claimant, but only donated the right to supervise the loading turns of transport companies in the park to the first and second defendants to avoid conflict. It is the same loading right that has been expanded unilaterally by the first and second defendants to include a right to exclude transport companies from operating in the park. That someone with delegated authority cannot override the individual who originally delegated his authority, which is expressed in the principle delegatus non potest delegare. The delegate is expected to exercise delegated power within the scope of the delegation and cannot act beyond those boundaries to contradict the original instruction. On this counsel referred to ECO against Calabar Local Government Council, that by exhibits MBR2, the extent of the third defendant's authority delegated to the first and second defendants does not extend to excluding any transport company from operating in a park. The court was asked to discountenance all the submissions of the first defendant and grant the reliefs in the suit. In opposition to the original summons, the second defendant filed a 42-paragraph counter affidavit deposed to by Comrade Dogu Jeremiah, the State Deputy Chairman, Administration, on the 26th day of May 2025. Annexed to the counter affidavit are 4 exhibits marked exhibits Retian 1 to Retian 4. In compliance with the rules of court, the second defendant filed a written address wherein these 2 issues were submitted for the court's determination. A, whether there is substantial dispute of fact from the claimant's affidavit and second defendant's counter affidavit, which renders the instance suit an improper case for originating summons. B, whether from the totality of the affidavit evidence before the court and the state of the law, the claimant is not entitled to any of the reliefs claimed in the originating summons, and the Honorable Court is entitled to resolve the sole question for determination set out in the originating summons against the claimant and dismiss the instance suit while granting the counterclaim. It was submitted on issue 1 that originating summons is not a proper procedure for the commencement of an action with substantial dispute of facts, relying on the provisions of Order 3, Rules 3 and 17 of the rules of this court, and the cases of Yenagoa against Adeleke, Amasike against Registrar General of CSC, and Olayo against Alegbe. Citations are supplied. That from the averments in the claimant's affidavit in support of the originating summons and the second defendant's counter affidavit, there is serious conflict of facts which takes the suit outside the realm of originating summons. The court was asked to resolve issue 1 in favor of the second defendant, convert the suit to complaint, and other parties to file relevant pleadings in the suit. With respect to issue 2, the learned counsel to the second defendant posited that while it is true that membership of trade unions is voluntary, pursuant to the constitutional right of freedom of association, in the instant case, the second defendant has not compelled the claimant to join his union, that having admitted in paragraph 31 of the claimant's affidavit in support of the original summons that he has been a lawful member of Britain, which the second defendant admitted in paragraph 26 of the counter affidavit, the question of the claimant's right of association or his membership of the second defendant is not an issue, relying on the case of Unity Bank PLC against Buhari, citation is supplied. That contrary to the claimant's submissions, that upon registration of his business name, same became a separate or distinct legal entity. In law, a business name upon registration is regarded together with the proprietor as one and the same person, unlike a company, which is a separate legal entity distinct from the owner. Counsel referred to FCDA against Unique Future Leaders International Limited, that the registered name of a company or business can be ascertained from the certificate of incorporation and by exhibit BM1 annexed to the affidavit in support of the originating summons. The name registered with the CSC by the claimant is the Bishop Interwar Motor Enterprise, with the objects of automobile sales, import and export services, and general contractors, that the business of motor park operation is not among the objects of the business name. Counsel referred to in Jemanzi against Share BP Port Harcourt. With respect to the claimant's contention that having registered under the Bayelsa State Registration of Business Places Law, he is automatically allowed to carry out business without registering with the first and second defendants. It was argued that the authority to establish, maintain, and regulate motor parks in Yenagoa Metropolis, including the Ekeke Motor Park, is the Yenagoa Local Government Council, pursuant to Section 36 of the Local Government Law of Bayelsa State. It was pursuant to the powers that the Local Government Council executed the agreement for the management and control of the Ekeke Motor Park, dated 19th of February 2025, which is Exhibit Written 2. That Exhibit Written 2 therefore prevails over Exhibit Written 4, which is inadmissible by virtue of Section 83 sub 3 of the Evidence Act, as same was prepared during the pendency of the suit. Counsel referred to Anagbado against Farouk, as well as Oseni Ekini against Olegbade, where it was held that document made by an interested party during the pendency of an action or in contemplation of litigation are inadmissible. That the claimant, who does not have any vehicle of his own with which to engage in the transportation business, could not have made any profit or lost any profit as claimed by him, that the claimant has failed to discharge the legal burden of honors of proof placed on him under Section 133 of the Evidence Act, relying on the cases of Ogbedu, Eguridu against Ogbako Teni and FBN Limited against Kakot Dynamics Services Limited. The court was asked to dismiss the claimant's case. With respect to the second defendant's counterclaim, it was posited that the defendant can counterclaim in an originating summons, relying on the case of Transocean Support Services Limited against NIMASA, that written being a voluntary organization, it has independence over its internal affairs and can take any decision it considers appropriate against its members, and such decision cannot be challenged. Counsel referred to HND against Ogona, Mbanefo against Moloku and others, and Aguma against APC and others. The court was asked to resolve issue 2 in favor of the second defendant, dismiss the suit, and grant the second defendant's counterclaim. It is pertinent to note that the claimant filed a 32-paragraph further affidavit deposed to by the claimant on the 30th day of May 2025. Annexed to the further affidavit are 3 exhibits, marked Exhibits A, MBR1, and MBR2. The learned counsel to the claimant also filed a reply on points of law on the same 30th day of May 2025, wherein it was further argued that since the existence of a directive of the state governor was admitted by both the first and second defendants in their counter affidavits, same cannot be denied by the second defendant in his written address, as facts admitted need no further proof, relying on Nigerian Shipbuilders Limited against Terminal Supra, that the second defendant cannot now turn around to claim the existence of substantial dispute of facts in the suit, that the authorization of the restoration of business places by the laws of Bayelsa State and the authority of the Yenagoa local government to give license to transport companies operating in the local government area is one that is of common knowledge and needs no further proof, pursuant to Section 124, sub 1 and B of the Evidence Act, that the letter written by the claimant to the Yenagoa Local Government Council is admissible under Section 14 sub D, 15 paragraph A to G, 20, 22, and 23 of the Evidence Act, because irrespective of the circumstances under which a document is obtained, same will be admissible unless the court is of the opinion that the desirability of admitting the evidence is outweighed by the undesirability of admitting same. That for a document made during the pendency of a suit to be inadmissible, same must have been made by a person interested when proceedings are pending or anticipated, involving a dispute as to any fact which the statement tends to establish, relying on the cases of Backway against South Wales Transport Company Limited and Bearmans Limited against Metropolitan Police District Receiver. Citations are supplied. There where, however, the interest of the maker of a document is purely official or as a servant or employee without a direct interest of a personal nature, the document is not excluded pursuant to the provision of Section 91 sub 3, now Section 83 sub 3 of the Evidence Act, that the third defendant has nothing to gain or lose from the instant proceedings, no personal interest in the instant proceedings, but is only joined as a party to the suit in the official capacity he occupies, that the letter of the third defendant is therefore admissible in the interest of justice. Counsel referred to Mark 4 against Shola. Citation is supplied. That the principle of res ipsa loquitur applies because by exhibits MBR2 and MBR3, the local government council did not give any exclusive powers to the first and second defendant unions, and the claimant has an operational permit from the local government council, relying on the case of Ubechi against Alaji Lukman, Sopra, as well as Chud Vatican against Ife Sinachi Industries, Sopra, that in law, a delegate is expected to exercise the delegated power within the scope of the delegation and cannot act beyond those boundaries to contradict the original instruction, relying on EPO against Calabar Local Government Council, Supra. The court was asked to grant the reliefs in the suit and dismiss the second defendant's counterclaim. It may be apposite to note that the second defendant filed a 16-paragraph further counter-affidavit deposed to by the second defendant, to which are annexed exhibits written A to written E on the 19th day of June 2025, while the claimant's counsel submitted by way of adumbration that the further counter-affidavit of the second defendant is incompetent and should be struck out because it was not filed within time as provided in Order 15, Rules 5 and 6 of the Rules of this Court 2017. The contention of the learned counsel to the second defendant is that the said process is competent because it is a response to the new facts raised by the claimant, relying on the case of Postcharis against Geoffrey. Citation is supplied. I have seen that the claimant's further affidavit filed on the 20th day of May 2025 was served on the second defendant on the 5th day of June 2025, while the second defendant filed a further counter affidavit on the 19th day of June 2025. I have also considered the provisions of Order 17, Rule 1, Sub 10 and 11 of the rules of this honorable court, and seen that the claimant raised new facts and issues in the further affidavit by pleading new exhibits A, MBR1, and MBR2. The second defendant is entitled to challenge such new facts and issues. Hence, a further counter affidavit filed on the 19th of June 2025. In the case of Tezongwe, Samson Abe against the Inspector General of Police and others, the appellate court quoted the decision in the case of Zenith Bank PLC against Bank Lowlands Investment Limited. Citation is supplied as follows, and I quote, I am therefore of the humble view that where new facts are introduced in a further affidavit, the opposing party is entitled to file a further counter affidavit, especially when hearing is yet to commence. In other words, a further affidavit cannot therefore be said to be the last permissible process as erroneously held by the learned trial judge. It is true that the rules did not expressly provide for the filing of further counter affidavit. However, the same rules did not also state that further counter affidavit cannot be filed in any circumstance. while I agree with respondents' counsel that courts should not encourage filing of processes endlessly, I am, however, of the humble view that every case has to be considered according to its given set of facts and circumstances. CUTC against Pamote, Adamu against Akulalia, and Ario against Julius Berger, Nigeria Limited. Clearly, there should be an end to the filing of processes and thus to litigation. However, since the applicant was the first to veer off the usual practice by raising new issues in his further affidavit, the respondents ought to be allowed a bite at the cherry by allowing them file a further counter affidavit as they have done. In the circumstances of this case, and interest of justice and fairness, the respondents were entitled to react to those new issues via their further counter affidavit. Moreover, the applicant did not show in any way he was injured by the filing of the respondent's further counter affidavit. End of quote. I therefore hold that the further counter affidavit filed by the second defendant on the 19th day of June 2025 is competent and same shall be relied upon in this suit. In response to the originating summons, the third and fourth defendants filed a composite counter affidavit of 17 paragraphs deposed to by the fourth defendant on the 30th day of May 2025. Annexed to the said counter affidavit is one document marked Exhibit NURTW1. The learned counsel to the third and fourth defendants filed a written address in support of the counter affidavit, wherein this loan issue was identified for the court's determination, whether or not there exists any controversy warranting the instance suit. It was posited on the loan issue that the facts leading to the instance suit are preventable because the directive of the governor of Bayelsa State is sacrosanct, being an executive order that should be obeyed, that the local government council is the only authorized body to restrict any transport company from operating in the Ikeki Motor Park, as the park is owned by the Yenagoa Local Government Council, that both the claimant and the first and second defendants are recognized by the local government council, and they should coexist in the local government-owned Ikeki Motor Park to avoid any unnecessary acrimony, that the authority delegated by the local government council to the first and second defendants to manage loading of vehicles at the park is not an exclusive authority and can be withdrawn, relying on the case of ECO against Calabar Local Government Council, where it was said that any act done beyond a delegated authority is null and void. Now, court's decision. Having considered the processes filed by the parties, this court shall determine this suit on the basis of the claimant's sole question, which is the sole issue submitted by the claimant for determination, and the second defendant's issue 1, which challenges the competence of the suit. The issues for determination are 1, whether there is substantial dispute of fact from the claimant's affidavit and the second defendant's counter affidavit, which renders the instance suit an improper case for originating summons. 2, whether or not by the joint interpretation of the provisions of Section 40 of the 1999 Constitution of the Federal Republic of Nigeria as amended, Section 1 and Section 12 of the Trade Unions Act, Cap T 14, LFN, and the directive of the Executive Governor of Bayelsa State on the first day of December 2024, the first and second defendants are authorized to have vesting authorities to determine the rights of transport enterprises to operate within or outside Bayelsa State, where such transport enterprises are properly registered with the state government under the Registration of Business Places Law of Bayelsa State, Cap R3 Laws of Bayelsa State. The contention of the second defendant on issue 1 is that since from the claimant's affidavit in support of the originating summons, there are substantial disputes of fact, the suit was improperly commenced by way of originating summons, and the court should order parties to file pleadings in the suit. The law is as rightly argued by the learned counsel to the second defendant that originating summons procedure is principally for matters relating to interpretation of any constitution, enactment, agreement, or any other instrument, and where there is no substantial disputes or issues of facts. See Order 3, Rules 3 and 17 of the rules of this court. In the case of Yombe, Dauka, and others against Congo Komi, citation is supplied. The Court of Appeal held as follows on when originating summons is appropriate to commence an action, and I quote, "The key issue is the propriety or otherwise of commencing the suit at the lower court via originating summons. Parties are adamant that for originating summons to be an inappropriate originating process, the dispute on fact must be substantial, affecting the live issue in the matter, where the disputes on the facts are peripheral, not material to the live issues. The action can be sustained by the originating summons. This is so because there can hardly be case without facts. It is facts that make a case, and dispute in facts that give rise to litigation. See Tanko against Modi. By and large, substantial dispute imputes a real material dispute or controversy of considerable importance, as opposed to an imaginary peripheral dispute. The question now is the dispute before the court substantial, which could only be resolved upon calling oral evidence based on pleadings. In determining whether a suit brought by an originating summons raises substantial dispute of facts, it is the nature of the claim and facts deposed to in the affidavit in support of the originating summons that is to be considered. Thus, mere filing of a counter affidavit to oppose the claims in an originating summons does not make the facts contentious and proceedings hostile in nature. Osai against Wakwa, FGN against Zebra Energy Limited, and Jimo against Aleshin Lawyer II. End of quote. I have looked at the facts deposed by the claimant in the affidavit in support of the instant originating summons and seen that the claimant is simply asking the court to determine whether by the provisions of Section 40 of the 1999 Constitution, as amended, Sections 1 and 12 of the Trade Unions Act, and the provisions of the Restoration of Business Places Law of Bayelsa State, the first and second defendants can determine the rights of transport enterprises operating within or outside Bayelsa State. What the claimant therefore seeks from the court is the interpretation of the law submitted with respect to the statutory powers of the first and second defendants to determine the rights of others to engage in transportation of goods and services in Bayelsa State. It is obvious from the affidavits of the claimant that the facts are not really contentious as to require oral evidence in the suit. Even if they are contentious, I hold a considered view that the disputes of facts are not substantial, such that they cannot be resolved via affidavit evidence or originating summons. In the circumstance, issue 1 is resolved in favor of the claimant. The court shall now proceed to determine issue 2 relating to the merit of the originating summons. It is, however, apposite to resolve the contention of the first and second defendants that exhibits MBR1 and MBR2 annexed to the claimant's further affidavit filed on the 30th day of May 2025 are inadmissible in evidence because they were made during the pendency of the instant suit. The law is strict that any evidence or document obtained during the pendency of a suit by an interested person is inadmissible and cannot be relied upon by a court of law. This is the intent of Section 83, sub 3 of the Evidence Act, which states, and I quote, "Nothing in this section shall render admissible as evidence any statement made by a person interested at the time when proceedings were pending or anticipated involving the disputes as to any fact which the statement may tend to establish." End of quote. See also the cases of UTC Nigeria PSC against Alhaji Abdul Wahab Lawal and Samuel Friday against Federal Republic of Nigeria. Citations are supplied. I have seen that while the claimant filed a suit on the 25th day of March 2025, the claimant's counsel wrote exhibit MBR1 on the 15th of May 2025. There is no doubt that the claimant's counsel wrote the letter on behalf of the claimant, who is an interested party to the instant suit. The claimant has a personal interest in the suit and its outcome. It is therefore disingenuous of learned counsel to have written to the third defendant seeking clarification over issues that have been tabled before the court for determination. Whatever clarifications he needed from the third defendant should have been sought and obtained before commencing the suit, and not to do so after submitting the issues before the court for interpretation and determination. I therefore agree with the first and second defendants that both exhibits MBR1 and MBR2 made during the pendency of the suit are inadmissible in evidence. The said exhibits are hereby discountenanced and rejected. See the case of soft oil and gas against EcoBank Nigeria PSC, citation is supply, where it was held as follows, and I quote, "It is right that a document made in the course of proceeding in the court for the purpose of the pending suit by interested parties are inadmissible in law by virtue of section 91 sub 3 of the Evidence Act and the case of MWT Nigeria Limited against PTF," end of quote. I have seen from the long questions submitted for the court's determination and the state of the claimant's pleadings that the claimant is seeking the interpretation of section 40 of the 1999 Constitution, sections 1 and 12 of the Trade Unions Act, and the provisions of the Registration of Business Places Law of Bayelsa State on whether the claimant is at liberty not to join the first and second defendants' trade unions and to operate his transport business free of intimidation, having registered under the Registration of Business Places Law of Bayelsa State. It may therefore be apposite to reproduce the provisions of the law submitted by the claimant for the purposes of clarity. Section 40 of the Constitution provides as follows, and I quote, "Every person shall be entitled to assemble freely and associate with other persons, and in particular, he may form or belong to any political party, trade union, or any other association for the protection of his rights, provided that the provisions of this section shall not derogate from the powers conferred by this Constitution on the Independent National Electoral Commission with respect to political parties to which that commission does not accord recognition," end of quote. Section 1 of the Trade Unions Act provides as follows, meaning of trade union. Sub 1, in this act, trade union means any combination of workers or employers, whether temporary or permanent, the purpose of which is to regulate the terms and conditions of employment of workers, whether the combination in question will or will not, apart from this act, be an unlawful combination by reason of any of its purposes being in restraint of trade, and whether its purposes do or do not include the provisions of benefits for its members. Sub 2, the fact that a combination of workers or employers has purposes or powers other than the purpose of regulating the terms and conditions of employment for workers shall not prevent it from being registered under this act, and accordingly, subject to the provisions of this act as to the application of funds for political purposes, a trade union may apply its funds for any lawful purpose for the time being authorized by its rules, including in particular, if so authorized, that of providing benefits for its members. Sub 3, a trade union within the meaning of this act shall not be treated as having been formed by reason only of A, any agreement between an employer and persons employed by him as to the terms and conditions of that employment, or B, any agreement for the instruction of any person in the profession, trade, or handicraft, or C, any agreement between partners as to their own business, any trading agreement between employers, or D, any agreement imposing restrictions in connection with the sale of goodwill of a business, end of quote. Section 12 of the Trade Unions Act provides as follows, and I quote, "Membership of trade union not to be restricted on discriminatory grounds." Sub 1, a person who is otherwise eligible for membership of a particular trade union shall not be refused admission to membership of that union by reason only that he is of a particular community, tribe, place of origin, religion, or political opinion. 2, Sub 2, if any person is refused admission to membership of a trade union in contravention of subsection 1 of this section, the union and every official thereof shall be guilty of an offense against this act. Sub 3, if any provision in the rules of a trade union is inconsistent with subsection 1 of this section, that provision shall, to the extent of the inconsistency, be void. Notwithstanding anything to the contrary in this act, membership of a trade union by employees shall be voluntary, and no employee shall be forced to join a trade union or be victimized for refusing to join or remain a member. End of quote. Section 3, not Section 1 as cited by the Claimants Council of the Registration of Business Places Law, Cap Act 3, Laws of Bayelsa State 2006, provides as follows, and I quote, registration of business places, sub 1, subject to the provisions of this law, there shall be registered in the manner prescribed the place of business of every company, firm, or individual carrying on any business in the state, provided that such registration shall not be required, A, where the business is carried on by a trustee in bankruptcy under any court order, or by the Administrator General, or any person acting under or appointed by the Administrator General or public trustee by virtue of any powers conferred on him by any law, or B, where the business is carried on directly by any government in Nigeria or by any government agency. Sub 2, power of governor to exempt. The governor may, by notice, signed by him and published in the Gazette, exempt from registration under this law the business place of any company, firm, or individual carrying on business in the state. End of quote. There is no doubt that both the first and second defendants are sued in their official capacities as representing the National Union of Road Transport Workers, NURTW, Bayelsa State Chapter, and the Road Transport Employers Association of Nigeria, RITIAN, Bayelsa State Chapter. These are duly registered trade unions, as the National Union of Road Transport Workers, NURTW, is listed as number 16 in the list of the restructured trade unions affiliated to the Central Labor Organization in Part A of the third schedule to the Trade Unions Act, with the jurisdictional scope of all workers engaged in transportation of passengers and goods by road, excluding the transportation of petroleum by road and transportation undertaken by self-employed persons. The Road Transport Employers Association of Nigeria, RITIAN, on the other hand, is listed as number 29 of Part C of the third schedule to the Trade Unions Act. While the law is right, as rightly argued by the Claimants Council, that the right to freedom to peacefully assemble and right to peaceful assembly and association in Section 40 of the Constitution is sacrosanct, and no individual is to be forced to be part of any association or trade union. I have however seen that the claimant is not a trade union, but a business name registered under the Companies and Allied Matters Act, as can be gleaned from the Certificate of Registration of Business Name Exhibit MB1 annexed to the affidavit in support of the originating summons. The provisions of Section 12 of the Trade Unions Act prohibiting discrimination, which is the fulcrum of the claimant's case, is to the effect that a person who is otherwise eligible for membership of a trade union shall not be refused admission to membership by reason only that he is of a community, tribe, place of origin, religion, or political opinion. The case of the claimant is not that he is qualified to be registered with the first and second defendants, but he was refused registration or admission on any of the discriminatory grounds listed in the Act. The allegation that the first and second defendants have taken over monopoly of the Ekeki Motor Park and have allegedly restricted the claimant from doing business in the park has nothing to do with denial of membership of trade unions to bring the provisions of Section 12 of the Trade Unions Act into play in this suit. To further buttress this point, subsection 4 of Section 12 of the Trade Unions Act talks about membership of a trade union by employees being voluntary, and that no employee shall be forced to join any trade union or be victimized for refusing to join or remain a member. The emphasis here is membership of a trade union by employees, and there is no indication that the claimant is an employee to take coverage under the said provisions, since the claimant is neither a trade union nor an employer or employee, and the instance suit does not relate to denial of membership of a trade union on any discriminatory ground, but for the permission to conduct business at the Ekeki Motor Park unhindered. I hold a considered view that the claimant cannot take shelter under the provisions of sections 1 and 12 of the Trade Unions Act, notwithstanding the provision of section 40 of the 1999 Constitution as amended, relating to right to peaceful assembly and association. It is also pertinent to note that even though by Exhibit BM3, dated 1st of June 2019, annexed to the affidavit in support of the urgent summons, the claimant, not being a trade union, was affiliated to the second defendant trade union. I have however seen that the affiliation has been withdrawn by the second defendant, as the claimant refused to work under the second defendant at the Ekeke Motor Park. These facts were also pleaded at paragraph 7 to 24 of the second defendant's counter affidavit and exhibits 3 and 2 annexed to the second defendant's counter affidavits is the letter of withdrawal of affiliation dated 21st of February 2025. Having not been affiliated with any trade union under the transport sector, I do not know how the claimant can undertake trade union activities considering the provisions of section 2 sub 1 of the Trade Unions Act, which prohibits the carrying out of trade union activities by unregistered trade unions. The jurisdiction of this honorable court, as circumscribed by section 254C1 of the 1999 Constitution as amended, does not extend to associations registered under the Companies and Allied Matters Act like the claimant, except if such association is either sued by a trade union as a defendant, or the suit by the association as a claimant relates to the registration of such association by the Registrar of Trade Unions. Since the issues in contention do not relate to registration, and the Registrar of Trade Unions is not a party to the suit, the claimant clearly lacks the local standard to approach this court for redress. I do not approach this court for redress. I so find and hope. See the case of AG Yenagoa State against the National Association of Government General Medical and Dental Practitioners. Citation is supplied where the Court of Appeal held as follows, and I quote, "It is not in doubt that the defendants are not a trade union. It is equally not in doubt that they are engaged in services for or in connection with hospitals and the treatment of sick as per paragraph 2D of the first schedule to the Trade Unions Act. The defendants having admitted this fact in paragraph 2 and 3 of their statement of defense. The argument of the defendants that the provisions of the Trade Disputes Act must be read as separate from those from the Trade Unions Act cannot be tenable because the Trade Unions Act defines the term essential services by reference to the Trade Disputes Act. Equally not tenable is the argument of the defendants that because they are not a trade union, they are not bound by the Trade Unions Act. This is because the provisions of the Trade Unions Act are meant to regulate the activities of not only bodies registered as trade unions, but those who are not so registered, but are keen on doing things that only registered trade unions can do, such as the defendants. So when the defendants acknowledge in paragraph 10 of their statement of defense that the second defendant via letter of 2nd December 2010 gave 21 days notice of strike to the claimant, it is an admission of the fact of doing the thing that only registered trade unions are permitted to do. Not only is this unlawful, it is criminal, end of quote. In the final result, I hope that since the claimant's affidavits in support of the urgent summons have no correlation with the provisions of sections 1 and 12 of the Trade Unions Act submitted for interpretation, he has failed to prove his case before the court. The loan question submitted by the claimant, which is the loan issue for determination, is hereby resolved against the claimant. The suit lacks merit and is hereby dismissed for want of proof. With respect to the second defendant's counterclaim, it may be apposite to restate the legal position that a counterclaim, which is also a cross-action, is governed by the same rules of pleadings as applicable to statement of facts. Such counterclaim is an independent and separate suit which is merely added to the main case for the purpose of convenience and expeditious trial. The onus is therefore on the counterclaimants who allege to prove their case by producing sufficient, cogent, and verifiable evidence to the satisfaction of the court. See Michael Sunday, Oroja, and others against Ebenezer Ilo Adeni and others, and Onguga against Tohile. Citations are supplied. I have however seen that the second defendant is asking for a declaration that the withdrawal of the claimant's affiliation by the second defendant counterclaimant is lawful. An order of perpetual injunction restraining the claimant defendant counterclaimant. Sorry, I take that again. An order of perpetual injunction restraining the claimant / defendant to the counterclaim from parading himself as an affiliate of the second defendant, and the sum of 100 million naira as general damages against the claimant for the embarrassment, expenses, and inconveniences occasioned by the claimant's suit, as well as the sum of 5 million naira as cost of this suit. The principal relief one of the counterclaim is a declaratory relief, which the law expects the claimant to prove and not to rely on any weakness in the case of the defendant to the counterclaim. The point being made is that this relief, which is declaratory in nature, cannot even be granted in the face of an admission by the defendant to the counterclaim or default of pleadings. See the cases of Engineer Nelson against Ifeinwa, Godfrey against Eugene Okafor, and Alhaji Shehu Yusuf against Bem Tilekado. Citations are also applied. Where the Court of Appeal held and as quote, the main claim being the declaratory relief, the first exponent was bound to prove his case on the balance of probability and by preponderance of evidence. He has to do this by cogent, credible, and plausible evidence, and must succeed on the strength of his case and not on the weakness of the adversary. See AG River State against AG Baesa, Nwokidu against Okanu, Dantata against Mohammed. In the case of Dape against Musa, this court by Aribi Jesse held as follows. The appellant sought before the tribunal declaratory reliefs. The declaratory reliefs are not granted as a matter of course and on the platter of gold. They are only granted when credible evidence has been laid by the person seeking the declaratory relief. A declaratory relief will be granted where the party seeking it is entitled to the relief in the fullest meaning of the word. The person seeking the declaratory relief must plead and prove the claim for declaratory relief without relying on the evidence called by the defendant. However, there is nothing wrong in a plaintiff taking advantage of any evidence adduced by the defense which tends to establish the plaintiff's claim. End of quote. Having pored over the affidavit in support of the counterclaim, I am not satisfied that the second defendant counterclaimant has proved to establish the counterclaim as required by law. Having withdrawn the claimant's affiliation, it is not for this court to pronounce on the legality of the withdrawal, and the second defendant counterclaimant has not referred the court to any statutory or case law authority in that regard. The counterclaim is also bound to fail, and same is accordingly dismissed for want of proof. The judgment is entered accordingly, and the parties are to bear their costs.
As the court pleases.
As the court pleases.
We are most grateful for the welcome.
Lord, we are very grateful for
as the court pleases, my lord.
Thank you. You have copies from Monday. You have copies from Monday when I return to Yenagoa.
As the court pleases.
Thank you. Yes, Registrar.
Yes, my lord.
Can you
Suit
call
number, case number 2, suit number NICN/Y. Yes, my lord.
Go ahead, call the second case.
Case number 2, suit number NICN/YEN/14/2025 between registered trustee of Nigeria Welders Association and 1, registrar of trade union, 2, Minister of Labor and Employment, 3, registered trustee of National Union of Welders. My lord, parties all absent, my lord.
Yes, who are the counsel in this one? Yes, who are the lawyers in this?
My
in
Lord,
this matter?
I appear
My
for
Lord,
the third
the
defendant.
first and second defendant.
I appear for the third defendant.
The name, please.
I'm waiting for my learned friends for the first and second to announce appearance.
Is the claimant's counsel online?
My Lord,
Okay, Remasi, can you announce your appearance?
most humbly, my Lord,
Yes.
Eremasi Alpheus, my Lord, for the first and second defendant, sir.
Yes, Blessing.
With the kind permission of the court, my
Yes.
Lord, my name is Joseph Opute. I appear with my learned friend Anthony Ndeze for the third defendant.
There are two decisions in this matter. You know, while I was working on the judgment, the claimant's counsel filed a motion for interlocutory injunction, which was argued last week. So
Yes,
I will take the ruling.
In the circumstance, my Lord, since today is for judgment.
No, I'm taking. I can't leave. I will take the ruling on the motion, which is very brief, before I proceed to the judgment.
My Lord, that is the right position. All motions
Yes.
must be disposed of before the judgment. My Lord is on firm footing. We are grateful to the court.
Thank you. Now, this is the ruling on the application. This ruling is in respect of the motion or notice filed by the claimant applicant on the 10th day of February 2026. The application prays the court for the following reliefs. One, an order of interlocutory injunction restraining the first and second defendant respondents by themselves, their servants, agents, or any person acting on their behalf from further doing any act of writing of conciliation letters to companies where the claimant applicant is existing as a trade union, or taking any step so as to forcefully recognize the third defendant respondent as a registered trade union and impose same on companies where the claimant applicant is existing as a trade union pending the determination of the substantive suit. Two, an order of mandatory interlocutory injunction compelling the first and second defendant respondents to restore the status quo ante bellum by withdrawing the letter dated 5th day of February 2026 with reference number MLBY/1B/NUNIWE/1/75 and cause to be written to the Social Performance Manager, Renaissance Africa Energy Company, Renaissance Industrial Area, Bayelsa State, and copied to 27 others pending the determination of the substantive suit. Three, an order restraining the defendant's respondents from continuing or repeating the wrongful act or from taking further steps in an action already started. And four, for such further order or orders as the court may deem fit to make in the circumstance. The application is supported by an affidavit of 17 paragraphs sworn to by Matthew Alori, the Bayelsa State Chairman of the claimant applicant. Annexed to the application are 5 documents marked exhibits 1 to 5. In the written address accompanying the application, the learned counsel to the applicant submitted one issue for determination, which is whether the claimant applicant has satisfied the requirements for the grant of an order of prohibitory and mandatory interlocutory injunction. It was submitted on the loan issue that the main purpose of granting an order of interlocutory injunction is to mitigate the risks of injustice the applicant will suffer during the period when the uncertainty over the violation of his legal right is resolved. Counsel referred to Total Nigeria PSC against VIIRA, citation is supplied. That since the grant of an application for interlocutory injunction is at the discretion of the court, which must be exercised judicially and judiciously, and the claimant applicant has made the requirements of existence of a serious question to be tried, whether damages will be an adequate compensation, and that the balance of convenience is on the side of the applicant, the court should grant the application. Counsel referred to Bello against AG Lagos State, Leasing Company Limited against Tiger Industries Limited, Ogunro against Duke, and Ido Wanson against Erebo. Citations are also supplied. In opposition to the application, the third respondent filed a counter affidavit of 17 paragraphs deposed to by Comrade Azibalua Amangala, the Bayelsa State Chairman of the third defendant, on the 23rd of February 2026. Annexed to the counter affidavit are two documents marked as A1 and A2. The learned counsel to the third defendant also filed a written address and submitted this sole issue for determination, whether the motion dated 10th of February 2026 is liable to be dismissed, having been filed after this suit had been concluded and adjourned for judgment. It was submitted on a loan issue that since the instance suit had been adjourned for judgment before the claimant applicant filed this application, the application is misconceived, particularly that no leave was sought and obtained from the court to reopen the case. On this, counsel referred to the cases of Odeze against Orazuluke Trading Company Limited, State Independent Electoral Commission, Ekiti State, Adun and others against Alile, and Shetima and another against Goni and others. That since the claimant applicant is not a registered trade union, it has no legal right to protect as it is engaging in illegal trade union activities, relying on Section 2 sub 1 of the Trade Unions Act, that the conduct of the claimant applicant who has been flouting the orders of this honorable court, restrain the claimant from carrying out illegal trade union activities is reprehensible, and the application should be dismissed with substantial cost. Counsel referred to Adeleye against the Executive Governor of Ogun State and Akapo against Hakib Habib. Citations are supplied. The claimant applicant filed a further affidavit of 5 paragraphs deposed by Matthew Alore, together with a reply on points of law, on the 25th day of February 2026. It was further submitted by the claimant applicant that since paragraphs 4 and 16 of the third respondent counter affidavit contain legal arguments and conclusions contrary to Section 1152 of the Evidence Act, they should be discountenanced and struck out. Counsel referred to AG Adamawa against AG Federation, NLL against ADIC Limited, and Bameyi against State. That Exhibit 5 was made by an interested party during the pendency of the suit and is therefore inadmissible under Section 83 sub 3 of the Evidence Act. Counsel referred to Magaji against Ogele that contrary to the submissions of the third respondent, a prohibitory injunction is an equitable remedy granted by courts to restrain parties from committing or continuing a wrongful act, often issued as interlocutory order to maintain the status quo. Relying on the case of military governor of Lagos State against Ojukwu, the court was asked to grant the application. Court's decision. I have carefully considered the application, the facts deposed in the various affidavits, and the arguments of the learned counsel to the parties in this case. The issue for determination is as formulated by the claimant, which is whether the claimant applicant has satisfied the requirements for the grant of an order of prohibitory and mandatory injunction, prohibitory and mandatory interlocutory injunction. The gist of the application, as deposed in paragraphs 4, 5, 6, 7, 8, 9, 10, 11, 12, and 13 of the supporting affidavit, is that while the instance suit is pending before the court and after the parties adopted their processes and the judgment reserved, the respondents wrote exhibits A to E aimed at undermining the suit and to cause harm to the claimant applicant and her members. It is supposed to note that the substantive originating summons was argued on the 8th day of December 2025, and the judgment had been reserved before the claimant applicant filed the instant application on the 10th day of February 2026. It is therefore pertinent to make the point, as rightly argued by the learned counsel to the claimant applicant, that once issues are brought before the court and parties have joined issues on the pleadings, as in the instant case, the parties are to wait for the court to decide the matter and not to take any step that will undermine the authority of the court. Put in another way, once a court of law is seized of a matter, the parties are under legal duty not to resort to self-help or take any step that will overreach the interests of the other party, pending the determination of the suit. Every court, including this court, has the inherent power to set aside any such action that tends to undermine the authority of the court. See the cases of military governor of Lagos State and others against Chief Emeka Odumegwu Ojukwu and another, LSA against Agbai, LSA Agbai against Samuel Akugwe, and Honorable Dele Abiodun against the Honorable Chief Judge of Kwara State and others. Citations are supplied. As apt as the legal position is with respect to the powers of the court to act decisively where a party resorts to self-help during the pendency of a suit, the court must not, however, lose sight of the fact that the application seeks for interlocutory reliefs pending the hearing and determination of the substantive suit. With the delivery of the judgment in the substantive originating summons, along with this ruling today, Friday, 6th of March 2026, I hold a considered opinion that the reliefs as prayed cannot be granted by the court. The application which was filed after judgment in the substantive suit had been reserved is now odious and academic, as interlocutory injunctions can only be ordered pending the determination of the substantive suit, unlike perpetual injunctions that are effective after the judgment in the suit had been delivered. See the case of Yusuf Babatunde Anisu against Prince James Adeleke Osayomi and others. Citation is supplied. The application therefore fails and same is hereby struck out. The ruling is entered accordingly, and I make no order as to cost.
As God pleases.
As the court pleases.
Now I go to the judgment. The claimant commenced this suit by way of originating summons dated and filed on the 17th day of June 2025, and submitted these 4 questions for the determination of the court. 1. Whether the first defendant's failure, refusal, and or neglect to notify the claimant accordingly that her application for registration as a trade union is defective, so as to enable the claimant to amend the application to the satisfaction of the trade union's registrar, or make a fresh application in place thereof, has satisfied the requirement of sections 3 sub 1 sub 5 6 and section 5 sub 1 5 sub 5 A and B of the Trade Unions Act Cap T14 LFN 2004 as amended. 2. Whether if the answer to the above is in the affirmative, the first defendant's failure, refusal, and or neglect to send a notice forthwith to the claimant in a prescribed form stating the grounds of refusal and specifying the date from which the time for appealing against the refusal is to run, and publish a notice to the like effect in the Federal Gazette contravenes section 5 sub 5A of the Trade Unions Act Cap T14 LFN 2004 as amended. And 3, whether the registration of the third defendant is not tantamount to an unlawful and improper duplication of effort of the claimant, in as much as the claimant has started the process of registration as a union on the 18th day of May 2023, while the third defendant started sometime in December 2024. 4, whether the first defendant's act of registering the third defendant despite the objections and protests by the claimant against the state registration has a chilling effect on Section 5 sub 2 and 3 of the Trade Unions Act, as the action contravenes same and therefore inconsistent thereto. The claimant claims the following reliefs against the defendants. 1. A declaration that the first defendant failure, refusal, and or neglect to notify the claimant accordingly that her application for registration as a trade union is defective, so as to enable the claimant to amend the application to the satisfaction of the trade union's registrar or make a fresh application in place thereof, is unlawful. 2. A declaration that the first defendant failure, refusal, and or neglect to notify the claimant forthwith in the prescribed form, stating the grounds of refusal and specifying the date from which the time for appealing the refusal is to run, and to publish a notice to the like effect in the Federal Gazette is unlawful. 3. A declaration that the registration of the third defendant is inimical to the claimant that sent objection to the first defendant, which is a permissible restriction within the contemplation of Section 5 sub 2 of the Trade Unions Act, Cap T 14, as amended. 4. A declaration that the first defendant's act of registering the third defendant, despite the objections and protests by the claimant against the said registration, is in contravention of Section 5 sub 2 of the Trade Unions Act as amended. 5. An order of this honorable court directing the first defendant to register the claimant as a trade union, inasmuch as the claimant has fulfilled the registration procedure to be registered as a trade union. 6. An order of this honorable court directing the first and second defendants to withdraw the certificate issued on the 28th day of May 2025 to the third defendant as a trade union in Nigeria. 7. An order of injunction restraining the third defendant, either by itself, servants, agents, and or previous, or any other person or persons howsoever designated from conducting and parading as a trade union. And 8. And for such further order or orders as this honorable court may deem fit to make and expedient to make in the circumstance of this case. The grounds for the originating summons are that 1, the position of Section 5 sub 1 of the Trade Unions Act, Cap T 14 as amended, is clear and unambiguous that where an application for the registration of a trade union is received by the registrar, the first defendant, and if the application appears to the registrar to be defective in any respect, he shall notify the applicant accordingly. 2, the first defendant refused, failed, and or neglected to comply with provision of Section 5 sub 5A of the Trade Unions Act as amended by not sending a notice in a prescribed form stating the grounds of refusing the claimant's application. 3, if the above is in the affirmative, the said notice shall specify the date from which time for appealing against the refusal is to run, and shall publish a notice to the like effect in the Federal Gazette, so as to enable the claimant to appeal to the second defendant. 4, the refusal to register the claimant as a trade union in Nigeria was not in line with Section 5 sub 1, 2, and 5A of the Trade Unions Act. And 5, the registration of the third defendant was not backed up by Section 5 sub 2 of the Trade Unions Act as amended. In support of the originating summons is an affidavit of 19 paragraphs deposed to by Matthew Alore, the Bayelsa State Chairman of the claimant, as well as annexed document marked exhibits NWA 1 and NWA 11 to NWA 11. In compliance with the rules of this court, the claimant filed along with the originating summons a written address wherein the claimant adopted and argued the questions for determination as the issues for determination in the suit. In arguing the 4 issues together, learned counsel submitted that Section 5 of the Trade Unions Act stipulates the procedure for registration of trade unions in Nigeria. The claimant applied to be registered as a trade union on the 18th of May 2023 and fulfilled the prescribed processes within the ambit of the law. The claimant then waited patiently for the first defendant to cause a notice of the publication to be published in the Federal Gazette for any public objection, or to notify the claimant that her application is defective. But the inability to notify the claimant the reason not to be registered as a trade union denied the claimant the opportunity to appeal to the second defendant, that despite the letter of the claimant solicitors dated 18th of October 2024, the first defendant still refused, neglected, and failed to register the claimant as a trade union, but went ahead and registered the third defendant in December 2024, despite written objections by the claimant in their letters of 6th of December 2024, 28th of January 2025, 18th of February 2025, and 9th of March 2025. That the general purpose of interpretation is to discover the intention of the lawmaker, and where the ordinary meaning of the words used is clear and unambiguous, the effect must be given to the words, and no resort can be made to extrinsic aid. That since the words used in Section 5 of the Trade Unions Act are clear and unambiguous, they ought to be given ordinary meaning. Counsel referred to AG Abia against AG Federation, Ondo State, AG Ondo against AG Ekiti, Okotiebo against manager, Olarewaju against the governor of Oyo State, Egbe against Yusuf, and Awolowo against Shagari. Citations are supplied. That in construing the statute, the court should opt for the interpretation that we make for the smooth working of the system which the statute has put in place, relying on Tuku against government of Gongola State, AG Ondo against AG Ekiti, and Rabiu against the state. That where a statute provides a mode of doing the thing, only that mode or method must be adopted and no other, relying on the case of Marwa against Nyaku. That the context of Section 5, Sub 1 and 2, and Sub 5A of the Trade Unions Act, as amended, is that if an applicant applies to be registered as a trade union, the registrar shall notify the applicant if the application is defective, cause a notice of the public application to be published in the Federal Gazette, stating the objections to the registration of the trade union in question, and forthwith stating the grounds of refusal and specifying the date from which the time for appealing against the refusal is to run, and to publish a notice to the like effect in the Federal Gazette so as to afford the applicant the opportunity to appeal to the minister against the refusal. The first defendant acted ultra vires by not registering the claimant as a trade union, but went ahead to register the third defendant that has the same jurisdictional scope and objectives. That the word used is shall, which makes it mandatory and not intended to be merely directed, relying on the case of Ezodoku against Maduka. The court was asked to resolve the questions and issues in favor of the claimant and grant all the release in the suit. In opposition to the originating summons, the third defendant filed a counter affidavit of 18 paragraphs, deposed by Comrade Dada Salmo Olabode, the National Deputy President, on the 14th of October 2025. And next to the counter affidavit are 6 documents marked Exhibit W1 to W6. In compliance with the rules of court, Learned Counsel also filed a written address wherein this loan issue is identified for the court's determination. Whether this suit as presently constituted is unmeritorious, hence liable to be dismissed. It was submitted on the sole issue that the claimant was incorporated under Part C of Hamman on the 28th of December 1985, Exhibit W1, and all the 3 registered trustees in Exhibit W1 are now deceased. That by Exhibit W2, the deceased registered trustees are yet to be substituted or replaced. That Mr. Matthew Alori, who filed the instance suit, is bereft of the standing to initiate the suit because the deceased registered trustees could not have given their consent and authority to Mr. Matthew Alori to depose to the affidavit in support of the suit. That Mr. Matthew Alori, who filed the suit in the name of the registered trustees of the claimant, needs to credibly demonstrate his claim to be entitled to the standing to maintain the suit. Counsel referred to the cases of Ezenwosu against Ngonadi and Akman and others against Omorin and others. citations are supplied. To the third defendant, according to the third defendant, from Exhibit W4, the claimant's application to be registered as a trade union was declined because at the time there was a registered trade union organizing welders in Nigeria, which is the Steel Engineering Workers Union of Nigeria. A second application to be registered as a trade union was submitted. There was also a trade union in existence, the Nigerian Welders and Fitters Union, which had not been dissolved. That the claimant is inviting the first defendant to act contrary to Section 3 sub 2 and 5 sub 4 of the Trade Unions Act, which forbid the registration of a trade union where an existing trade union is sufficiently representing the interests of the class of persons intended the union intends to represent. That the claimant's subsequent application for registration as a trade union is illegal, and the first defendant is entitled to discountenance said that by Section 3 sub 2 of the Trade Unions Act, the first defendant is empowered to regroup an existing union, which was done through the registration of the third defendant. It was upon the application of the third defendant promoters that the first defendant regrouped the third defendant by separating the fitters from welders so that the third defendant will strictly be for welders only. According to learned counsel, the registration of the third defendant is in line with the law, as the first defendant caused a notice of the application to be published in the Federal Gazette via Exhibit W5, that says by Section 7 of the Trade Unions Act, the cancellation or withdrawal of a certificate of a trade union can only be grounded on either fraud or mistake. The absence of fraud or mistake is conclusive proof that the requirements of the Act for registration of the third defendant had been complied with, that the suit lacks merit and should be dismissed with substantial cause in favor of the third defendant. Upon receipt of the third defendant's processes, the claimant filed a 28-paragraph further and better affidavit deposed to by Mr. Matthew Alori on the 3rd day of November 2025. And next to the further and better affidavit are exhibits NWA 12 to NWA 15. Learned counsel also filed a reply on points of law on the same 3rd of November 2025. It was submitted in the written reply address that in law, he who asserts must prove, relying on Section 131 of the Evidence Act and the case of Mrs. Rosemary against Yayi Maina, citation to supply, that Exhibit W3 does not disclose that the registered trustees of the Nigerian Welders Association are deceased because there is no death certificate from the National Population Commission, affidavit of death, or an obituary poster or funeral program before the court. Counsel referred to Exhibit W3 and argued that same is not authenticated, being electronic document, which is generally inadmissible in evidence, having failed to meet the provisions of Section 84, sub 4 of the Evidence Act with respect to certificate of authentication, that there was no time in the year 2012 the claimant applied to the first defendant to be registered as a trade union, because as at the time the claimant submitted Exhibit W8 to the Registrar of Trade Unions to be registered, there was no trade union with the jurisdictional scope in existence, that the Steel Engineering Workers Union of Nigeria never existed, and the Nigerian Welders and Fitters Union was proscribed by the Abuja Judicial Division of this court in suit number NICN/YEN/73/2016 between Nigeria Welders and Fitters Union and registered trustees of Iron and Steel Senior Staff Association of Nigeria and 14 others, that the contention of the third defendant is therefore false and misleading, relying on the case of Durowaye against UBMPSC, that Exhibit W4 is a public document and is not certified to be admissible, relying on the case of Ezechukwu against Onwuka. The court was ought to enter judgment in favor of the claimant and grant all the reliefs in the suit. It is apposite to note that the first and second defendants did not file any process in opposition to the suit. Now, cost decision. Having considered the processes by the parties, this court shall determine this suit on the basis of the 4 questions and issues identified and argued by the claimant's counsel. But before I consider the merit of the suit, it is apposite to first determine the 3rd defendant's notice of prior objection, challenging the court's jurisdiction filed on the 14th of October 2025, urging the court for an order dismissing this suit in limine for lack of jurisdiction to entertain the suit as presently constituted. The rationale for this position is that jurisdiction, being the threshold issue, must be determined first before considering the merit of the suit, as any proceeding conducted in the absence of the requisite jurisdiction amounts to an exercise in futility. See the cases of J.A. Adekoye and others against Nigeria Security Printing and Minting Company Limited and others, Mrs. Chime Ogbeyolu Ayodele against Mr. Sule Isaac Ayodele, and Shell Nigeria Exploration and Production Company Nigeria Limited against Federal Inland Revenue Service. Citation is supplied. In support of the notice of prior objection is an affidavit of 15 paragraphs deposed to by Comrade Azibalua Amangala, the Bayelsa State Chairman of the 3rd defendant, to which are annexed Exhibit N1 to N4. In the written address filed in support of the notice of prior objection, the 3rd defendant identified this single issue for the court's determination, whether the Honorable Court has a jurisdiction to entertain this suit, having been filed by the registered trustees of the claimant, who are all deceased. It was submitted on the loan issue that the claimant was incorporated under Part C of Hamman on the 28th day of December 1985, with Samuel Joseph, Sunday O. Aibomia, and Ibrahim Audu, who are all now deceased, as the registered trustees, that since their demise, new registered trustees have not been appointed to replace or substitute them till date, that when attempts were made in the past to replace the late trustees, the CSC mandated them to settle the outstanding annual returns before it could entertain any application to replace the deceased registered trustees, but they could not make the payment. Hence, the application did not see the light of the day. Counsel referred to exhibits N3 and N4. It was further argued that Mr. Matthew Alore's claim that he had the authority and consent of the claimant to depose to the affidavit in support of the suit is therefore false, because when the suit was filed, there was no living or legal person to have given such authority and consent, that he failed to demonstrate how he obtained the authority and consent in line with the evidential requirement of proof as alleged by him. Counsel referred to Mainstream Bank against Mewada and Sadiq and others against Fashion, that the onus is on Mr. Matthew Alore to prove his claim that the registered trustees are alive and how they gave him the authority and consent to institute the suit. That the suit was filed through misrepresentation and concealment of material facts to deceive the Honorable Court and is therefore incompetent and an abuse of court process. The court lacks the jurisdiction to entertain the suit as filed by the deceased persons. Counsel referred to Kashingi against Masoro, Okon against Aji, Eyesan against Sanusi, SPDC against Pesu, and Zoom against Jinadu, as well as Ezenwosu against Ngonadi. Citations are also applied. The having not substituted the dead registered trustees with living ones, the claimant as presently constituted lies a juristic capacity or personality to initiate and maintain this suit, as one cannot build something or nothing and expect it to stand, referring on Magfoy against USC and Navy Captain Olufemi against Jinadu. The court was asked to grant a notice of prior objection and dismiss the suit in its entirety with substantial cause in favor of the 3rd defendant. In opposition to the notice of prior objection, the claimant filed a 12-paragraph counter affidavit deposed by Matthew Alore on the 3rd of November 2025, to which are annexed exhibits A to D. In the written address filed in support of the counter affidavit, the claimant adopted the loan issues drafted and argued by the 3rd defendant. It was submitted that all the welders in Nigeria came together in 1985 and formed the Nigerian Welders Association for the protection of their interests in line with the provisions of Section 39 and 40 of the Constitution and Section 673, sub 1 and 2 of the Companies and Allied Matters Act, that even though the Nigerian welders have been elected by established procedures of body, that the trustees are acting in the interest of the association, relying on the case of Wonsu against Okeke, that Mr. Matthew Alore, who is the Bayelsa chairman and the principal member of the Nigerian Welders Association, has the authority of the claimant and other executives and principal members of the claimant to depose to all the facts in the affidavit in this suit, as the claimant is a legal personality and can sue and be sued. Counsel referred to Gani Fawemi against Nigerian Bar Association number 2. Citation is given. That by exhibit N3 of the third defendant, the claimant is a juristic person, having been incorporated at the Corporate Affairs Commission in 1985, relying on the case of Apostolic Church, Elisha, against AG Midwest, that the burden of proof is on the third defendant, who asserts that the registered trustees of the claimant are all deceased, but the third defendant has failed to establish the allegation. Counsel referred to Section 131, sub 1 and 2 of the Evidence Act and the cases of Kasalba against Okonko and Sefik against Mona. Citations are supplied. That the third defendant produced a death certificate from the National Population Commission, which is the primary legal document of proving death in Nigeria under Section 17 of the Births, Deaths, etc. Compulsory Registration Act, and also the Evidence Act, or affidavit of death, obituary, or poster, as well as a funeral program. It was further posited that Exhibit N4 is an unauthenticated electronic document, which is generally inadmissible in court without a certificate of authentication, pursuant to Section 84 of the Evidence Act, that the notice of non-objection is the same as the contention in the third defendant's counter affidavit to the originating summons, contrary to the law, that it is in the interest of public policy that there should be an end to litigation. Referring to Okon against Udo, the court was asked to dismiss the notice of non-objection for being an abuse of court process, as the third defendant has not used the judicial process bona fide and properly, relying on the case of Ikine against Ederede. The third defendant applicant filed a 6 paragraphs further and better affidavit deposed to by Comrade Aziba Lua Amangala, the Bayelsa State Chairman of the third defendant, together with a reply on points of law on the 17th of November 2025. The learned counsel to the third defendant identified this sole issue for determination, whether by virtue of Mr. Matthew Alore's counter affidavit dated 3rd of November 2025. He proved his claim that the registered trustees of Nigeria Welders Association are the claimant in this suit, and he had the consent and authority of the said registered trustees to depose to the affidavit in support of the suit. It was submitted that from the processes in this suit, Mr. Matthew Alore is not the claimant, and he is therefore saddled with the legal responsibility to prove that the registered trustees of the claimant are still alive, and how he got their consent or authority to institute the suit. That since the suit was commenced by originating summons and to be determined on affidavit evidence, there is no need to produce certificate of authentication as required under Section 84, so 4 of the Evidence Act. That a document attached to or exhibited with an affidavit forms part of the evidence adduced by the deponent and is therefore properly before the court without the formality of certification, relying on the cases of Ondoka against Obot and another, and Ilorin East local government against Alas Sinrin and another. Citations are supplied. That only the registered trustees of the claimant have the locus to initiate and prosecute this suit in their names, and not the claimant, who is not one of the registered trustees. The court was out to dismiss the suit for want of jurisdiction with substantial cost in favor of the third defendant. It is pertinent to note that the claimant filed a further counter affidavit of 5 paragraphs deposed to by Matthew Alore together with a reply address on the 21st day of November 2025. It was further submitted by the claimant that a bare denial as borne by the third defendant applicant is not enough because they are supposed to provide particulars and grounds of the fact challenge. that paragraphs 4 and 5 of the third defendant applicant's further and better affidavit are legal arguments and conclusions contrary to section 115 sub 2 of the Evidence Act, and the court was ought to strike out the said offending paragraphs. Counsel referred to AG Adama against AG Federation, that the onus of proof is on the third defendant who asserts that he must prove the allegation with credible evidence, relying on section 131 of the Evidence Act and the case of Womilolu against Anibire, that the third defendant who asserts that the registered trustees of the claimant are deceased has failed to prove said through the production of death certificate from the National Population Commission or a medical certificate pursuant to section 17 of the Birth Death Compulsory Registration Act, that the claimant who is aggrieved has the right to seek legal redress, and the claimant, not Matthew Alore, has the legal capacity or local standing to bring the suit. Thus, as a general rule, only persons who are natural or artificial persons created by law, not subject to legal disability, can sue or be sued, relying on Obasanjo against Buhari. The court was out to discountenance the third defendant applicant's submissions and dismiss the notice of plenary objection. The first and second defendant's respondents did not file any process in respect of the notice of plenary objection of the third defendant. The fulcrum of the third defendant's objection is that since the registered trustees of the Nigerian Welders Association was registered under the SY Part C of KAMA, now Part F of the Companies and Allied Matters Act 2020, and all the registered trustees are now late and have not been replaced. The deponent to the affidavit in support of the original summons, Mr. Matthew Alore, does not have the local standing to institute the instant suit, as the late trustees could not have given him the consent and authority to institute the suit on behalf of the claimant. I have seen from Exhibit N3 attached to the affidavit in support of the notice of plenary objection that the registered trustees of the Nigerian Welders Association, the claimant, was incorporated under the then Land Perpetual Succession Act, Cap 98, on the 28th day of December 1985, with Samuel Joseph, Sunday O. Aibomia, and Ibrahim Audu as the appointed trustees. There is therefore no doubt that the claimant, as presently constituted, is a corporate body imbued with the powers to sue and be sued in its corporate name as such trustee, see section 823 sub 2 of the Companies and Allied Matters Act, Cap of the Companies and Allied Matters Act 2020, which states as follows, and I quote, upon being so registered by the Commission, the trustee shall become a corporate body in accordance with the provisions of section 830 of this Act. Section 830 of KAMA 2020, on the other hand, provides as follows, and I quote, from the date of registration, the trustee shall become a body corporate by the name described in the certificate, and shall have a perpetual succession, B, a common C, if they so wish, C, power to sue and be sued in its corporate name as such trustees, D, subject to section 836 of this part, power to hold and acquire and transfer, assign, or dispose of any property or interest therein belonging to or held for the benefit of such association in such manner and subject to such restrictions and provisions as the trustees met without incorporation, hold or acquire, transfer, assign, or otherwise dispose of the same for the purposes of such community, body, or association of persons. Sub 2, the certificate of incorporation shall vest in the body corporate all property and interest of whatever nature or tenure belonging to or held by any person in trust for such community, body, or association of persons. Sub 3, a certificate of incorporation, when granted, shall be prima facie evidence that all the preliminary requisitions herein contained and required in respect of such incorporation have been complied with, and the date of incorporation mentioned in such certificate shall be deemed to be the date on which incorporation has taken place. End of quote. I have held in this decision that the claimant, as presently constituted, is a body corporate and has the powers to sue and be sued in its corporate name. The issue of the legal status or capacity of the claimant is therefore never in doubt, going by the certificate of incorporation annexed to the affidavit in support of the notice of non-objection. See the case of Yusufu against registered trustees of Christ Apostolic Church, and Reverend Monday, Michael Idiom, and others against the incorporated trustees of Divine Assemblies of Christ Church of Nigeria. Citations are also supplied. On the third defendant's allegation that all the trustees of the claimant are deceased, hence they could not have given the claimant consent or authority to institute the instance suit. The onus of proof is no doubt on the third defendant, who alleges to establish the allegation with credible and verifiable evidence as required under sections 131 to 134 of the Evidence Act. I have forever seen in this suit that apart from the facts deposed in the affidavit in support of the notice of non-objection, which in any case have been denied by the claimant, there is nothing before the court to substantiate the allegation that the said trustees, Joseph Samuel, Aibomia O. Sunday, and Ibrahim Audu, are late or deceased. Exhibit N4 does not show that the trustees are deceased, and there is no indication as to when and where they died. There is no certificate of death or any document showing the death of the said registered trustees before the court. The law is that the best way of establishing or proving death in criminal cases which are found relevant to this civil suit is either a medical certificate of death showing that the deceased is dead and the cause of death, or the viva voce evidence of the medical doctor who performed an autopsy on the body of the deceased to testify that the deceased had died. See Kofoorola Sahid against the people of Lagos State. Citation is supplied. See also section 17 and 19 of the Birth, Death, etc. Compulsory Registration Act. The deponent to the affidavit in support of the urgent summons, Matthew Alore, describes himself at paragraphs 1, 2, 3, and 4 of the supporting affidavit as the Bayelsa State Chairman of the claimant, and by virtue of his position, he is very conversant with the facts of the case, and that he knows the claimant as the umbrella body of the warders in Nigeria, that he has the authority and consent of the claimant and other principal executive members of the claimant to depose to the affidavit. The third defendant needs more than mere averments in an affidavit to disprove these assertions by the deponent to the affidavit. The lone issue in the notice of non-objection is therefore resolved against the third defendant applicant. The notice of non-objection fails and same is hereby dismissed. The court hereby assumes jurisdiction in the matter and shall not proceed to determine the substantive originating summons. The crux of the claimant's case is the alleged failure of the first defendant to comply with the requirements of sections 3 and 5 of the Trade Unions Act, Cap T14 LFN 2004, relating to the claimant's application for registration as a trade union and the subsequent registration of the third defendant as a trade union. It may therefore be apposite to reproduce the statutory provisions which are germane to the determination of the issues in this suit. Section 3, sub 1 provides an application for the registration of a trade union shall be made to the registrar in the prescribed form and shall be signed. A, in the case of a trade union of workers by at least 50 members of the union. B, in the case of a trade union of employers by at least 2 members of the union. Sub 2, no combination of workers or employers shall be registered as a trade union, save with the approval of the minister on his being satisfied that it is expedient to register the union, either by regrouping existing trade unions, registering a new trade union, or otherwise howsoever, but no trade union shall be registered to represent workers or employers in a place where there already exists a trade union. Sub 3, no staff recognized as a projection of management within the management structure of any organization shall be a member of or hold office in a trade union, whether or not the members of that trade union are workers of a rank junior, equal or higher than his own. Is such membership or of the holding of such office in the trade union will lead to a conflict of his loyalties to either the union or to the management. Sub 4, for the purposes of subsection 3 of this section, a person may be recognized as a projection of management within the management structure if authority, powers, duties, and accountability, which are reflected in his condition of service, as such as normally inherent in a person exercising executive authority, whether or not delegated within the organization concerned. Sub 5, every application made pursuant to subsection 1 above shall state the name under which it is proposed, and the trade union to which it relates shall be registered, and the address of the office, which, if the union is registered, is to be the registered office. Sub 6, every such application shall be accompanied by 2 copies of the rules of the union and by a list showing A, the name, address, age, and occupation of each of the persons by whom the application is signed, and B, the official title, name, address, age, and occupation of each official of the union. Section 5 provides as follows. 5.1, where an application for the registration of a trade union is received by the registrar, the following provisions of this section shall apply, provided that if the application appears to the registrar to be defective in any respect, he shall notify the applicant accordingly and shall take no further action in relation thereto until the application has been amended to his satisfaction or a fresh application is made in place thereof. Sub 2, the registrar shall cause a notice of the application to be published in the Federal Gazette stating that objections to the registration of the trade union in question may be submitted to him in writing during the period of 3 months, beginning with the date of the Gazette in which the notice is published. Sub 3, within 3 months, after the end of the set period of 3 months, the registrar shall consider any objections submitted to him during that period, and if satisfied, A, that no proper objection has been raised, B, that none of the purposes of the trade union is unlawful, C, that the requirements of this act and of the regulations with respect to the registration of trade unions have been complied with, shall subject to subsection 2 of this section and to section 6 of this act, register the trade union and its rules. Sub 4, the registrar shall not register the trade union if it appears to him that any existing trade union is sufficiently representative of the interests of the class of persons whose interests the union is intended to represent. Sub 5, if the registrar refuses to register the union, A, he shall forthwith send to the applicants a notice in the prescribed form to that effect, stating the grounds of refusal and specifying the date from which the time for appealing against the refusal is to run, and shall publish a notice to the like effect in the Federal Gazette, and B, any official or member of the union may, within the period of 30 days, beginning with the date so specified, appeal to the minister against the refusal. Sub 6, the registrar, on registering a trade union, shall issue a certificate of registration, which, unless it is proved that the registration of the union has been cancelled, shall accept in any proceedings for the cancellation of the registration of the union on the ground that its registration was obtained by fraud or as the result of a mistake, be conclusive evidence that the requirements of this act and regulations with respect to registration of trade unions have been complied with, and that the trade union is authorized to be registered and is a trade union for the purposes of this act. Sub 7, notwithstanding anything to the contrary contained in this act, the registrar shall, the coming into effect of this section of this act, register the trade union specified in Part A and Part C of the third schedule to this act, and on such registration, the said trade unions shall have all the powers and duties of a trade union registered under this act. End of quote. The claimant had applied to the registrar of trade unions, the first defendant, to be registered as a trade union on the 18th day of May 2023, and waited for the notice of the application to be published in the Federal Gazette for any objections from the public, or for the first defendant to notify the claimant of any defect in the application so as to enable the claimant appeal to the Honorable Minister of Labor and Employment, the second defendant in this suit. The application and all the supporting documents are exhibits NWA1, NWA2, and NWA3 annexed to the affidavit in support of the originating summons. When the claimant did not receive any notice from the first defendant, they wrote through their solicitors to the second defendant, later dated 18th of October 2024, exhibit NWA4. But despite the letter, the first defendant refused and neglected to register the claimant, but went ahead and registered the third defendant as a trade union on the 28th of May 2025, whose jurisdictional scope is the same as that of the claimant, as can be gleaned from exhibits NWA5 and NWA6 annexed to the affidavit in support of the originating summons. The registration of the third defendant was done on the 28th of May 2025 via the letter of registration exhibit NWA7, despite the claimant's protest and objections to the registrations of the third defendant via exhibits NWA8, NWA9, NWA10, and NWA11. It is obvious that both the promoters of the claimant and the third defendant once belonged to the Nigerian Welders Association before the registration of the third defendant as a trade union, as can be gleaned from Exhibit W1 annexed to the third defendant's counter affidavit in opposition to the originating summons, where the deponent to the counter affidavit, Comrade Dada Salmo Olabode, was elected as the national president of the association on the 4th day of December 2021. From Exhibit W4, it is obvious that efforts were made to register the association as a trade union on the 3rd of May 2012, but the application was declined by the Registrar of Trade Unions via Exhibit W4 dated 23rd of May 2012 on the ground that there was in existence the Steel Engineering Workers Union of Nigeria. I must say that there is another certificate of return attached to the claimant's further and better affidavit as Exhibit NWA12, which indicates that the person elected as the national president of the association on the 4th of June 2021 was Comrade Godfrey Etim. The question before this honorable court is whether the first defendant acted rightly and within the law in registering the third defendant as a trade union, despite the application and protest or objections of the claimant to the registration of the third defendant. I have seen in this suit that contrary to the claimant's contention that an application was submitted to the registrar of trade unions for registration in 2012, the third defendant's Exhibit W4 annexed to the third defendant's counter affidavit shows that the first defendant declined the registration of the claimant on the ground that the class of persons the claimant intended to organize was already covered by an existing union, the Steel Engineering Workers Union of Nigeria. I have seen that the claimant's counsel did not rely on any case law authority where the section 3 and 5 of the Trade Unions Act submitted for interpretation have been decided upon, apart from the general arguments that since the provisions are clear and unambiguous, they should be given their ordinary grammatical meanings, particularly that the word shall used in the provisions does not give room for any discretion on the part of the registrar of trade unions. In the case of the registered trustees of the National Association of Community Health Practitioners of Nigeria and others against Medical and Health Workers Union of Nigeria, citation is supplied. The Supreme Court made it clear that by sections 3 sub 1 and 5 sub 2 of the Trade Unions Act, the registration of a trade union is not automatic, but at the discretion of the Registrar of Trade Unions after he must have made his investigations and become satisfied, and that the decision to register or not to register a trade union inheres in the Registrar of Trade Unions and not the Minister of Labor and Productivity. See also the case of Erasmus Osawe against Registrar of Trade Unions. Citation is supplied. I have seen in this suit that contrary to the contention of the claimant, that no publication was made in the Federal Gazette, Exhibit W6, annexed to the third defendant's counter affidavit, is the official gazette dated 31st of October 2024, volume 3, number 186, which is a publication of the application of the National Union of Nigerian Welders for any objection to the registration of the said body as a trade union. Section 5 sub 6 of the Trade Unions Act presupposes that a certificate of registration of a trade union issued by the registrar is conclusive evidence that the requirements of the Act and regulations with respect to the registration of the trade unions have been complied with. The only ground for any application for the cancellation of such registration of the trade union is either that the registration was obtained by fraud or as a result of a mistake. To succeed in this suit, for an order of court withdrawing the certificate issued to the third defendant on the 28th of May 2025, the claimant must establish that the registration of the third defendant was obtained through either fraud or as a result of mistake, which the claimant has failed to show in this suit. I therefore hold that having published the application of the third defendant for registration as a trade union in the Federal Gazette before registering the third defendant, I cannot see any vitiating feature in the third defendant's registration to warrant the cancellation or withdrawal of the certificate issued to the third defendant by the first defendant. I have also seen that the claimant's principal claims or reliefs before the court are declaratory in nature. The burden is therefore on the claimant to produce credible evidence without relying on the evidence of the defendants. The law is that declaratory reliefs are not granted even on admission or default of pleadings by the defendant. In the case of Alhaji Shehu Yusuf against Bimtile Kado, the Court of Appeal for Ibrahim Ali and Yaso JCA held as follows, and I quote, the main claim being a declaratory relief, the first respondent was bound to prove his case on the balance of probability and by preponderance of evidence. He has to do this by cogent, credible, and plausible evidence and must succeed on the strength of his case and not on the weakness of the adversary. See A.G. Rivers against A.G. Baesa. See Nwokikdu against Okanu. In the case of Dape against Musa, this court, by review JCA, held as follows. The appellant sought before the tribunal declaratory reliefs. Declaratory reliefs are not granted as a matter of course and on the platter of gold. They are only granted when credible evidence has been laid by the person seeking the declaratory relief. The declaratory relief will be granted where the party seeking it is entitled to relief in the fullest meaning of the word. The person seeking the declaratory relief must plead and prove the claim for declaratory relief without relying on the evidence called by the defendant. However, there is nothing wrong in a plaintiff taking advantage of any evidence adduced by the defense which tends to establish the plaintiff's claim. See also the cases of Mr. Ebon, John Ebon against Mr. Okon Ebon and Devian Ondogu against Chief Atim Meba and another. Citations are also supplied. In the final result, I hope that the claimant has failed to prove the case before the court, or the four questions, which as the issues for determination in this suit are resolved against the claimant. The suit lacks merit and is hereby dismissed for want of proof. Judgment is entered accordingly. The parties are to bear their respective costs.
Please.
Noble Lord, I want to deeply appreciate the court for the well-considered judgment. This is a judgment that has come with a lot of cerebral fecundity, and we are grateful to the court. And we only wish the court that justice of this nature will continue to emanate from our bench. We are most grateful to the court. We are grateful to the court.
Thank you.
My Lord, we are also grateful for the court industry put into this matter, and we always pray that the good Lord continue to bless my Lord and give my Lord the wisdom to do the right thing at all.
Thank you. You have copies on Monday. When there is
We are grateful to the court.
Yenagoa. Thank you. Austin.
Yes, my lord.
Registrar, can you call the last case on the list?
Okay, my lord. Case number 3. Suit number NICN/5EN/5M/2024. Between Mr. Festus Oyewelu Uba and one Taipei Contracting Nigeria Limited. Mr. V.O. Adefara. 3. Mr. Greenville Alberto. 4. Mr. Lucas Pablo. 5. Mr. Tofos Johnson. 6. Mr. Jarvis Joshua Dagado. My Lord, pass it all after my Lord.
Yes, who are the counsel in this suit?
My Lord, you are here, sir.
Yes.
Very respectfully, my Lord. My name is Tamfree Jekiri. My Lord, I hold the brief of Akinwumi Omishade for the respondents.
That is T.S. Jekiri.
Yes, my Lord. T.S. Jekiri, sir.
All right. Whose brief?
I hold the brief of Akinwumi Omishade.
Yes, all right.
Thank you very much, my Lord.
You're welcome. Yes, any other counsel?
Hello, sorry, my Lord.
Yes.
My Lord, sorry, the claimant is online. I can see him online, my Lord.
The claimant's counsel or the claimant?
The claimant, yes, sir, the judgment creditor, my Lord, is online. I can see him online.
Okay, what of the counsel, Mr. Emeroye?
He is not, my Lord. He sent me a message that he will be having a judgment in High Court, so that he will not turn online.
Okay.
Yes, my Lord.
Thank you. This is a counsel ruling. This is a composite ruling in respect of 2 applications filed by the parties in this suit. The judgment creditor applicant filed a motion on notice on the 12th day of April 2024, praying for the following reliefs. 1, an order of this honorable court committing Mr. V.O. Adefala, Director Nigeria, Mr. Savelin Alberto, Logistics and Security Coordination Manager, Mr. Lucas Fabro, Project Manager, Mr. Tagofo C. Johnson, HR Management and Industrial Relations Manager, and Mr. Jarvis Jesoy Arias, Delegado, Construction Manager, NOPL Project. Respondents alleged contemnors, respectively, who are the alter ego prime movers and principal officers of the first respondent, Saipan Contracting Nigeria Limited, to Correctional Center for disobedience of order of the Honorable Court as contained in Clause 3 of the judgment order made on the 13th day of February 2023. 2, and for such order or other orders as the court may deem fit to make in the circumstances. In support of the application is an affidavit of 11 paragraphs deposed to by the judgment creditor applicant. And next to the affidavit are 3 documents marked exhibits A, B, and C. In compliance with the rules of this court, the judgment creditor applicant filed a written address wherein this sole issue was identified for the determination of this court, whether from the material facts presented by the applicant to the court, the 2nd to 6th respondents alleged contemnors are not liable to be committed to a correctional center. It was submitted on the single issue that this honorable court has the inherent powers to punish for contempt, referring to the cases of Umaru against Aliyu, Ogunlana against Dada. Citations are supplied and Section 69 and 72 of the Sheriffs and Civil Process Act. That the 2nd to 6th respondents have refused and neglected to comply with Clause 3 of Exhibit A. Hence, they should be punished in order to preserve the reputation, honor, and integrity of the court. Counsel referred to Ogwebego against PDP and Joe Best Estate Development against Nzeugo. Citations are supplied. There is neither an appeal nor an order of stay of execution of the judgment of the Honorable Court that to succeed in an application for committal proceeding, the applicant must establish the following. A, that there is a subsisting valid judgment or order which is clear and unambiguous. B, that the terms of the judgment or order are clear and unambiguous. C, the respondents had proper notice of the terms of the judgment or order. And D, there is proof that the terms of the judgment or order have been broken or breached. Counsel referred to Abbas against Solomon and Ogunukan against Digbani. Citations are supplied. The court was out to invoke its disciplinary powers and commit the second to six respondents alleged contemnors to a correctional center. The court was out to resolve the loan issue in favor of the judgment creditor applicant and grant the application. In opposition to the application, the respondents filed 44-paragraph counter affidavit deposed to by Egofose Johnson on the 6th day of May 2025. Annexed to the counter affidavit are 7 documents marked exhibits A1 to A7. In compliance with the rules of court, the respondents filed a written address wherein these 2 issues were identified for the determination of the court. 1, whether the respondents in all the circumstances of this case are in willful and deliberate disobedience to the order of this honorable court of February 13th, 2023, to warrant their committal to a correctional center. And 2, whether the service of the forms 48 and 49 amount to improper service that vitiates the entire proceedings and the abuse of court process or not. It was submitted on issue 1 that content must be a deliberate act of defense against a valid order of court, and where compliance is impossible due to factors beyond the alleged contentor's control, content cannot be established. That genuine efforts towards compliance mitigate contempt allegations. Counsel referred to Odu against Jale Oso and Akimbola against Federal Republic of Nigeria against Ajimoda against Ajimoda. That from paragraphs 20 to 40 of the counter affidavit, the respondents made genuine efforts to comply with the judgment by making an open appointment for the applicant to attend a reputable orthopedic hospital, the Rehoboth Specialist Hospital, Port Harcourt, River State, for the removal of the screw and plates inserted in his pelvis, that the applicant and his counsel have refused, failed, or neglected to respond to any of the communications with them regarding the appointment nor attend the hospital, that the respondent's compliance with paragraph 3 of the judgment of February 13th, 2023 is contingent on the applicant's attendance at the Rehoboth Specialist Hospital for medical assessment and the consequential surgery, which he has deliberately refused, failed, and neglected to adhere to. That since contempt of court is an offense of a criminal nature, this must be proved beyond reasonable doubt, and the applicant has failed to demonstrate beyond reasonable doubt that the respondents have deliberately and willfully disobeyed the order of this honorable court. The court was out to resolve issue 1 in favor of the respondents and hold that they are not in disobedience of the court's judgment because they have taken steps to comply with the decision, but the claimant and his counsel have deliberately frustrated their genuine and deliberate efforts at complying with the judgment. With respect to issue 2, learned counsel argued that the judicial process is not to be used for an improper purpose, and the initiation of contempt proceedings in bad faith or to frustrate an opponent amounts to an abuse of judicial process. Counsel referred to Saraki against Kotoi and Ume against IGP, that the applicant and his counsel, who have been frustrating the compliance with the court order, cannot approach the court to seek to punish the respondents for non-compliance, that the instant committal proceeding is done in bad faith to harass, torture, and embarrass the respondents. It was further argued that proper service of Form 48 and 49 is crucial for valid contempt proceedings, referring to Patrick against Elder David, as well as Order 9 Rule 13 of the Judgment Enforcement Rules, that while Form 49 should be endorsed and served 2 days after service of Form 48, the applicant improperly served both forms at the same time by pasting same on the first respondent's office wall, together with a motion for committal on the 19th of March 2025, that the respondents were not afforded the 2 days required of them to respond to the Form 48. Counsel referred to Ogbone against Aja and Adebanke against Ojelabi. Citations are supplied. That the validity of contempt proceedings is heavily dependent on the proper service of Form 48, the notice of consequence of disobedience, and Form 49, the application for committal, and failure to properly serve these forms vitiates contempt proceedings. That while personal service is mandatory, there is no evidence of proper personal service of forms 48 and 49 on the respondents, which is a fundamental irregularity that renders the entire proceedings null. The court was out to resolve issue 2 in favor of the respondents and dismiss the application. It is apposite to note that the judgment creditor applicant filed a 10-paragraph further affidavit and a reply on points of law on the 16th of October 2025. With respect to the respondents' issue 1, it was implied that the respondents are in willful and deliberate disobedience of the judgment of the Honorable Court, as contained in paragraph 3 of the judgment dated 13 February 2023, that there is no appeal against the judgment, hence the judgment must be obeyed, relying on Uchi against Sabo and AG Anambra against AG Federation. That the respondents have not taken any positive step to invite the applicant for discussion before any purported arrangement with the Rehoboth Hospital, and that even if there was any such arrangement, it was not done within the 30 days window allowed by the Honorable Court. On the respondents' issue 2, it was implied that it was when the second respondent refused service of the Form 49 and a motion of notice for committer that the court ordered for a substance service on the respondents. The service of the Forms 48 and 49 was done in compliance with the order of court, and therefore valid service on the respondents, and not an abuse of court process. That abuse of court process is an omnibus and multifaceted one that is of infinite variety, depending on the peculiar circumstances and facts of a case, referring to Okafor against Wenke, that the instance suit is not an abuse of court process. The paragraphs 5 to 43 of the respondent's counter affidavit are evasive and did not challenge the affidavit in support of the application, and they contain extraneous matters by way of legal arguments of law and facts, contrary to section 115 sub 1 and 2 of the Evidence Act. Constant referred to Ola against University of Ilorin, Zakire against Mohammed, Emeka against Chuba Ikweazu. Citations are supplied. The court was urged to strike out the offending paragraphs of the respondent's counter affidavit. That having not challenged the fact that the respondents did not make any arrangement for the removal of the implant in the applicant's pelvis on or before the expiration of the 30 days grace period, they have admitted that they disobeyed the order of court. Also referred to Mabamije against Otto, Oziri against EFCC, and APC against Lere, as well as Global Soap and Detergent Industries Limited against Sunshine Oil Chemical and Development Company Limited. Citations are also applied. The court was urged to discountenance the respondents' processes and grant the application. Now, cost decision. Having considered the judgment creditor's application for committal proceedings, it is supposed to first determine the notice of non-objection filed by the respondents on the 6th of May 2025, challenging the competence of the committal proceedings for being incompetent, thereby depriving the court of the requisite jurisdiction to entertain said. It is therefore incumbent on the court to determine the notice of non-objection first, because the issue of jurisdiction is a threshold issue, and any proceeding conducted in the absence of the requisite jurisdiction amount to exercise in futility. See J.A. Adekoye against Nigeria Security Printing and Minting Company Limited and others, Mrs. Chimi against Mr. Sule, Share against Federal Inland Revenue. Citations are also applied. The notice of non-objection, which is by way of a motion or notice, press for the following reliefs. 1, a declaration that the service of Form 48, dated February 5th, 2024, Form 49, dated March 29, 2024, and the motion or notice dated April 5th, 2024, on the applicants in the manner as done is null and void, having not complied with the mandatory provisions of Order 9, Rule 13 of the Judgment Enforcement Rules 2024. 2, a declaration that the order of this Honorable Court, as contained in paragraph 3 of the judgment of February 13, 2023, which is the bedrock of the said Form 48, Form 49, and the committal proceedings, was directed to the first applicant alone. 3, a declaration that the service of Form 48, dated February 5, 2024, Form 49, dated March 29, 2024, and the motion on notice, dated April 5, 2024, on the 5th to 6th applicants is wrongful, unwarranted, and an abuse of court process. 4, a declaration that the second to 6 applicants ought not to have been joined as parties to the committal proceedings. 5, an order striking all the names of the 5th to 6th applicants from the committal proceedings. 6, an order setting aside the purported service of Form 48, dated February 5th, 2024, Form 49, dated March 29, 2024, and the motion on notice, dated April 5th, 2024, on the applicants for being improper, incompetent, and an abuse of court process. 7, an order dismissing the committal proceedings commenced by the respondent for being incompetent. 8, and for such further or other orders as the court may deem fit to make in the circumstances of the application. The notice of objection is supported by a 31-paragraph affidavit deposed to by Bofose Johnson, to which is annexed 1 document marked Exhibit A1. In compliance with the rules of court, the applicants filed a written address wherein these 4 issues have been identified for determination. 1, whether service of Form 48 and Form 49 in all the circumstances of this case is proper service and in accordance with the laid-down rules and Eastern laws. B, whether the 2nd to 6th applicants were wrongly joined to the contempt proceedings. C, whether in light of all the circumstances of this case, the applicants are liable to be committed to a correctional center for disobeying the judgment of this honorable court delivered on February 13, 2023. And 4, whether the committal proceedings as constituted does not amount to an abuse of court process. I've noticed that the arguments in the notice of pre-objection are the same as the ones in the substantive application. The applicant's issue 1 of the notice of pre-objection is whether the service of Forms 48 and 49 simultaneously with the application for committal is null and void, taking into consideration the provisions of Order 9, Rule 13 of the Judgment Enforcement Rules and Section 72 of the Sheriffs and Civil Process Act, Cap S6, LFN 2024. Let me state straight away on issue 1 that while I appreciate the very robust and tried submissions of the applicant's counsel, the service of the committal processes ought to be personal, and that Form 49 ought to be served 2 clear days after the service of the Form 48 on the alleged contemnors. The point must however be made that the service of the court processes were done in compliance with the court order for substance service made on the 4th day of March 2024 and the 10th day of March 2025. And from the affidavit of service deposed to by Maurice Daniel Silvanus, a bailiff of this honorable court, on the 20th day of March 2025, at pages 213 to 217 of the case file, the court order for substance service was complied with on the 19th of March 2025 at about 2:43 p.m. Since the service of the committal processes were made pursuant to an order of court, I hold a considered view that the service was proper service in the circumstance, particularly as the court ruled on the same 10th of March 2025 that the service of court process effected pursuant to the order shall be proper service on the respondents. Issue 1 is therefore resolved against the applicants in the notice of pre-objection. See the case of Alhaji Abdullahi Madala Alhaji Balaguso, citation is supplied, where the appellate court held as follows, and I quote, "It is the discretion of the court to order any of the methods of service prescribed by the rules of court to be used, and can also make other than any of those prescribed by the rules for service of the originating processes on the defendant, provided that it can bring the matter to the knowledge of the person to be served. Hence, a substance service duly ordered and executed is as effective in law as a personal service. I find support for this opinion of mine in the case of Porter against Fraudenberg, where the court held that there seemed to be no reason why a method other than any of those expressly prescribed by the rules should not be used, provided that it can bring the matter to the knowledge of the person to be served, end of quote. With respect to issue 2 of the notice of prior objection, whether the second to 6 applicants were wrongly joined to the contempt proceeding, I have seen the submissions of the applicant's counsel that since the 3rd paragraph of the judgment in question, which is the fulcrum of the instant committal proceedings, is against the first applicant alone, the 2nd to 6th applicants were wrongly joined to the suit, and their names should be struck out of the suit. The instant committal proceedings was filed on the 5th day of February 2024 via the motion ex parte, wherein the first relief was for leave of court to initiate contempt proceedings against the applicants, particularly the 2nd to 6th applicants in this notice of preliminary objection, being the principal officers of the first applicant. The application was argued on the 4th of March 2024, and the court granted leave for the commencement of the committal proceedings against, including the 2nd to 6th applicants. This order was made pursuant to the provisions of Order 63, Rule 6 of the rules of this court, which provides that where the contemnor is not a natural person, the court or the applicant shall seek leave of the court to proceed against any of the principal officers of the contemnor or against the chief executive officer, managing director, the company secretary, or any other responsible and highly placed officer of the contemnor. The designations and offices of the 2nd to 6th applicants are all indicated against their respective names, and the applicants have not denied that the 2nd to 6th applicants occupy the respective offices indicated on the court processes. They may not be the chief executive director or managing director, but they are principal officers occupying highly placed offices in the first applicant. The applicants contend that the 2nd to 6th applicants have complied with the aspects of the judgment concerning them, and they were wrongly joined to the suit as the outstanding paragraph 3 of the judgment is directed at the first applicant alone. This argument is of no moment because being parties to the judgment in question and officers of the first applicant, they cannot pick and choose the aspect of the judgment to obey. If they can obey the monetary aspects of the judgment, they should also be able to obey the outstanding paragraph 3 of the judgment to sponsor the respondent to a reputable orthopedic hospital to remove the screw and plate implanted on his pelvis. Issue 2 is therefore resolved against the applicants in the notice of preliminary objection, and the court holds that the 2nd to 6th applicants were properly joined to the instant suit. With respect to issue 3, issues 3 and 4, I have seen that these issues form the fulcrum of the applicant's objection to the motion on notice for committal. The issues of whether the applicants are in deliberate disobedience of the judgment of this honorable court delivered on the 13th of February 2023, and also whether the instant committal proceeding is an abuse of court process shall be determined during the consideration of the substantive committal proceeding. There is no way the court will determine these issues without delving into the merit of the substantive application for committal. See the case of Dangote Industries Limited against Mr. Razak Idowu Aragbada and others, where it was held as follows, and I quote, as it stands, the issues as to whether the first and second respondents' land falls within the lands acquired by the Lagos State government by the 1993 revocation notice is an issue that must be left for the substantive trial of the dispute. In the same vein, since the issue forms the foundation of the first and second respondents' case, it cannot be predetermined. The position of the law, as judicially approved by the Supreme Court, in the case of Ovonwo against Woko, is that must guard against preempting or predetermining such life issues that are to be resolved or settled at the trial of the substantive suit. See also Adetona against Zenith Bank International PSC, Akinri Missy against Max Nigeria Limited, and Oti against Oga. End of quote. The notice of preliminary objection therefore fails, and same is hereby refused and dismissed. The court shall now proceed to determine the substantive motion for committal filed by the judgment creditor applicant. Having pored over the judgment creditor applicant's motion on notice for committer filed on the 12th day of April 2024, including the supporting affidavit, exhibits, the processes of the respondents, and the written addresses of the parties. The issue for determination is as identified by the judgment creditor applicant, which is whether from the material facts presented by the applicant to the court, the 2nd to 6th respondents alleged contemnors are not liable to be committed to a correctional center. The respondents issue 2, relating to the validity or competence of the service of the originating process, originating committer processes, forms 48 and 49, has been considered and determined in the respondent's notice of preliminary objection. It is apposite to first make the point that a contempt or committer proceeding, like the instant one before the court, is sui generis and a quasi-criminal proceeding, which has the possibility of affecting the liberty of the party who is alleged to have disobeyed the order of court. It is on this basis that courts are expected to exercise some restraint by ensuring that all the required legal steps are taken and the entire legal requirements are strictly complied with by the applicant before such proceeding can be successful. See INEC against AGK, citation is supplied, and URE is AG against HCEK, where it was held, and I quote, as the committer proceedings touches on deprivation of freedom of movement and liberty of the person, the service and procedure is applied strictly, and from strict application of the rules vitiates the proceedings. End of quote. See also Comrade MZ ZD against Comrade Justice Kotu, citation is supplied. I forever consider the processes filed by the parties and seeing that while the judgment creditor applicant is urging the court to commit the 2nd to 6th respondents to a correctional center for disobeying paragraph 3 delivered on the 13th of February 2023, requiring the sponsorship of the judgment creditor applicant to a reputable orthopedic hospital to remove the screw and plate implanted on the claimant's pelvis. The respondents contend that they are not in deliberate disobedience of the said judgment because they have made positive efforts to comply with the court's judgment by making an appointment for the claimant and writing to him to report at a reputable hospital, the Rehoboth Specialist Hospital, Port Harcourt, for medical care to remove the screw in his pelvis, but he neither responded to the letters nor reported at the hospital, thereby frustrating the efforts of the respondents to comply with the court judgment. It is obvious from paragraph 3 of the judgment order of the judgment of 13th of February 2023, which is annexed to the affidavit in support of the application as Exhibit A, that this honorable court ordered the first defendant to sponsor the claimant to a reputable orthopedic hospital to remove the screw and plate implanted on the claimant's pelvis as spread in Relief 6 of the originating processes filed on the 10th of November 2017. It is in evidence that the monetary aspects of the judgment of 13th of February 2023 have been complied with, as can be gleaned from Exhibit A2 annexed to the respondent's counter affidavit, indicating that the sum of 22,700,000 naira was paid to the judgment creditor applicant. It is manifest from the avalanche of the evidence by the defendants, as can be gleaned from Exhibits A1, A2, A3, A4, A5, A6, and A7, that as far back as 20th December 2023, before the commencement of the instant committer proceeding on the 5th of February 2024, the respondents made arrangement with the Rehoboth Specialist Hospital, Port Harcourt, for the removal of the screw and plates implanted in the judgment creditor applicant's pelvis as ordered by the court, and communicated same to the applicant, requesting him to visit the said hospital for the medical care. There is no doubt that the said Rehoboth Specialist Hospital, Port Harcourt, is a reputable specialist orthopedic hospital, and this fact has not been controverted by the applicant. There is no indication that the applicant either responded to these correspondences from the respondents, requesting him to visit the hospital for the treatment in compliance with the order of court, or that he visited the said hospital. He seemed to be preoccupied with the recovery of the monetary aspects of the judgment. And after the sum of 22,700,000 naira was paid to him, he still took no step concerning his treatment, despite the letters of the respondents, until the filing of the instant committal application. From Exhibit A1, annexed to the respondent's counter affidavit, the respondents requested for the cost of the treatment from the hospital, and the hospital requested to see the judgment creditor applicant for physical examination and investigations before the cost estimate will be known. This was communicated to the applicant's counsel via Exhibit A2, dated 21st December 2023, by Exhibit A3, dated 18th of January 2024. The respondents booked appointment for the applicant at the said Rehoboth Specialist Hospital for the 22nd to 26th of January 2024, and communicated same to the applicant's counsel. And by Exhibit A4, the hospital communicated its decision to keep the appointment open for the applicant to assess the required care anytime he visits the hospital. Let me make the point that the court did not order the payment of any monetary amount to the applicant for the cost of the treatment, but that the respondent should sponsor the treatment of the applicant at any reputable orthopedic hospital. I do not think it is in the interest of the applicant, who has been carrying these screws and plates in his pelvis for years now. I take that again. I do not think it is in the interest of the applicant, who has been carrying these screws and plates in his pelvis for years now, to refuse to honor the invitation. I therefore agree with the submissions of the respondents that the compliance with paragraph 3 of the judgment cannot be realized without the attendance of the applicant at the hospital for medical assessment and the consequential surgery. Without him visiting the hospital, it is practically impossible to assess his medical condition with a view to removing the screw and plates on his pelvis as ordered by the court. The respondents are obviously not in deliberate disobedience of the court's decision, having written to the hospital and also the applicant's counsel for the treatment of the claimant, but his decision not to respond to the letters or visit the said hospital as requested. I therefore hope that, having not been in deliberate disobedience of the court order, the respondents cannot be convicted for contempt as prayed by the applicant in this application. The suit is clearly an abuse of court process and therefore bound to fail. The point must, however, be made that the said paragraph 3 of the court's judgment is still valid and subsisting, and the respondents must not renege in their efforts to comply with same for the applicant to receive the desired medical care. It is in the interest of the applicant to cooperate with the respondents in that regard for the screws and plates inserted in his pelvis to be removed. The loan issue is resolved against the judgment creditor applicant. The application fails and same is hereby struck out. Ruling is entered accordingly, and I make no order as to cost.
Thank you very much, my lord, for this well-considered ruling. My lord, we are most grateful. Thank you so much, sir.
Thank you. You're welcome. So you have copies on Monday.
As God please.
All right. Thank you. Austin, registrar. Mr. Austin.
Yes, my lord.
Is that all for the day?
Yes, my lord. That's all, my lord.
All right. Thank you. Enjoy your weekend. Bye-bye.
Thank you, my lord. Thank you, my lord.
Austin, well done, eh?
Yeah.
He's on mute.
Thank you, sir. I appreciate that. Sorry, I will call you. My phone is there off.
Yeah, I can imagine. So sorry. So sorry. We're